All right, I think we'll go ahead and begin the seminar on healthcare reform. Are you ready for the next wave of healthcare reform? I am Brett Busacker. I'm a partner at Holland & Hart in Boise, Idaho, and I specialize in employee benefits and executive compensation, and we've been doing a lot of work in the Affordable Care Act arena over the last few years, and one of the big issues that's coming up, obviously, is the shared responsibility penalties, and we wanted to chat and talk with our clients and employers about some of the obligations associated with that. I have here with me Brett Clark, who is an attorney in our Boise office as well, and I'll let him introduce himself really quickly.
I do a lot the same as Brett does. I do a lot of healthcare reform compliance, especially over the last few years. So this is a big issue for a lot of employers, and we're happy to help out. Also, as we go through, we're going to have, if you have any questions, please just type them into the chat box, and if we have time, we'll cover them. If not, then we'll send out just sort of a summary of the answers to the questions, if we can.
Right, we have a lot to cover. We have a lot of slides, which you've hopefully got, and maybe have even looked through a little bit. We're not going to attempt to cover every detail on the slides. We'd like you to use the slides kind of as our, guidance in this area. We've talked a lot about this with a lot of different people, and so we'll go through this fairly quickly in terms of the background information, with the hope that the last half of the presentation will focus on just solutions for employers. So if you have a question and we cover something too briefly for you, please feel free to shoot us a question, and we'll either answer it at the end, or if we run out of time, we'll send out an answer, as Brett pointed out. So just to get covered, we're going to cover, as I mentioned, the shared responsibility penalties and shared responsibility requirements and what employers should be focusing on. Really, there's two areas of focus. One is tracking employees and determining which employees you have to offer coverage to, or pay a penalty if you don't offer coverage. And the other activity or major challenge that employers are going to be facing in terms of implementing compliance with this is just reporting to the IRS the forms that the IRS will require, and the timing for those forms and the content of those forms. And at the end of the seminar, as I mentioned, we'll spend hopefully the last 20-25 minutes talking about things that employers may want to be thinking about to address cost increases associated with insurance driven by the Affordable Care Act, how to address compliance, and just some strategies to be looking at. With that, I'll just jump right in. Just as a little bit of background, I assume many of you know a lot about the Affordable Care Act, and others maybe quite a bit less, but I'd like to kind of put in context the shared responsibility penalties in terms of how they relate to other issues or other programs of the Affordable Care Act that are being implemented simultaneously. So first of all, you have the individual mandate, and the individual mandate is the requirement that all individuals obtain coverage or pay a penalty. So that's a penalty or a tax that individuals pay if they don't have coverage, and that individual mandate is trying to force as many people as possible into the country's healthcare system to try, as you probably remember talking about, bending the cost curve. Getting more people into the health insurance system will help manage or maintain costs. And the other aspect of the Affordable Care Act are the health insurance exchanges, and the health insurance exchanges are essentially a carrot because they offer coverage. They're a good place for people to go, or an easy place for people to go to explore their medical insurance options. And for some people, they may even be entitled to premium assistance or cost-sharing subsidies. And so for individuals between 100% of the federal poverty level and 400% of the federal poverty level, basically families up to $95,400 a year, a family of four, those individuals will be entitled or eligible for some sort of cost sharing, some sort of premium assistance, if they're not otherwise covered by their employer. And that brings us to the employer shared responsibility penalties and how those penalties play into the grander scheme of the Affordable Care Act, because now certain employers of a decent size are going to be required to offer coverage, or if they don't offer coverage, they're going to be required to pay a penalty. And so in general, the big picture is individuals are being pushed through taxes and penalties imposed on them a carrot is being offered by giving the insurance marketplace and the credits that are going to be available for those people on the exchange. And employers are going to be required to make a decision to either offer coverage or pay a penalty. And if they don't offer coverage, their employees can go to the exchange, and if they satisfy the income thresholds, receive some assistance on the exchange. So that's the scope of the shared responsibility penalties and how they fall into the broader Affordable Care Act scheme. So who's subject to these penalties? Well, that's actually a challenging question in and of itself. First of all, the statute requires that applicable large employers, which are employers with 50 or more full-time or full-time equivalents, offer affordable coverage that's minimum value or pay a penalty. And then the administration, because of the problems in implementing the Affordable Care Act, delayed the enforcement of the penalties for 2014. So these penalties were originally scheduled to become applicable in 2014. They pushed it out to a first effective date of 2015. But in addition to pushing out the deadline for compliance, they increased the number of employees an employer has to have in order to even be subject to these requirements. So for 2015 alone, just 2015, because in 2016 the threshold drops back down to 50. So for 2015 alone, an employer that has 100 or more full-time or full-time equivalent employees will be subject to these shared responsibility requirements and either offer coverage that's affordable and minimum value or pay a penalty. And as we'll discuss in more detail, we shouldn't limit our thinking as to how many employees my business has at a specific location or what a company is, calls or describes as its employees, because these rules apply on a much broader basis. The number of employees that you're counting are the employees of all the controlled groups. So that means any affiliated businesses or companies that have common ownership and common control. That's the employer for purposes of calculating how many employees you have in determining whether you're going to be subject to the shared responsibility requirements in 2015. And we'll get into more detail a little bit later on that. So let's go through and talk a little bit about how you run these calculations. First of all, you count all of your employees that are working 30 hours a week or more, or 130 hours a month or more as one FTE. So then that gets you a baseline number. And then you add up all of the hours of all your other employees, and you divide that number by 120, and that gives you an additional number. So if we run an example, going over to the example page, if an employer has 80 full-time employees working 30 hours a week or more, and 25 other employees that work a combined 2,500 hours in June of 2014, which would be about 25 hours per employee, you take that 2,500 hours and divide it by 120, that gives you 20.83, and you add that 20.83 to 80, and that gives you 100.83 for the month of June. You then add that 100.83 to all the other months for the period, the 12-month period, and you divide that by 12, and if that's 100 or more, you're subject to the shared responsibility requirements in 2015. As a little bit of a break, some employers are going to get a break if they have a lot of seasonal employees, because if seasonal employees are essentially making or breaking you for purposes of the rule, and those seasonal employees are working 4 or fewer months out of the year, and it's those seasonal employees that are throwing you over the threshold, whether it's the 50-employee threshold for 2016 or the 100-employee threshold for that special year 2015, you can take those seasonal employees out of the calculation and then rerun the numbers and see if you're still above the threshold. So that's an important aspect of this for industries that use a lot of seasonal workers. But keep in mind that we're really talking about seasonal workers and not just simple fluctuations in the number of employees you employ during the year. So I've already talked a little bit about the transition relief for 2015, but there are a couple of caveats or a couple of catches that you need to be aware of. So for 2015 alone, if you have 100 or more FTEs, you're subject to the requirement. It's not 50 for 2015. The 50 comes back in 2016, but if you want to be eligible for this higher threshold in 2015, you have to be able to document in a Form 1094-C that you satisfied the requirement to be entitled to this transition relief, which basically means you can't have manipulated your workforce or terminated employees or dropped coverage throughout 2015, because if you do any of those things, you kind of try and circumvent the rule or restructure your workforce, or you drop coverage. If you had coverage before, then this transition relief is not available to you. All right, so that kind of gives us the large employer threshold, and so hopefully we went through that fairly quickly. We're making pretty good time. So now let's talk a little bit about what the shared responsibility penalties are. The shared responsibility penalties are essentially penalties that are imposed on an employer, and there's actually two types. There's a $2,000 no coverage penalty, which is imposed on an employer if the employer offers no coverage to its full-time employees, okay, or at least 95% of its full-time employees. So if an employer currently has or implements some type of group health plan and offers that coverage to at least 95% of its full-time employees, it wouldn't be subject to the no coverage penalty, but it may be subject to a secondary penalty, which is called the insufficient coverage penalty, and that's a penalty that's imposed on an employer that maintains a group health plan, but that group health plan doesn't offer a minimum value, or the coverage is too expensive to the employees as defined by the Affordable Care Act, which we'll talk a little bit more about shortly. So a couple things to keep in mind. As I mentioned, you calculate the shared responsibility penalties on a monthly basis, so that $2,000 number and the $3,000 number on the prior page, those are annual penalties, and you calculate the penalty on a monthly basis depending on whether the individual was offered coverage for the month or not. And if they're a full-time employee, you have to offer them coverage. And if you don't offer them coverage in the most part for the entire month, then you pay the penalty, except for in a couple situations where somebody's employed in the middle of a month or terminates employment during the middle of the month. Otherwise, you pay 1/12 of the $2,000 or 1/12 of the $3,000 penalty, the annual penalty, for each month in which an individual doesn't have affordable coverage. As I mentioned before, it's really important to not think too narrowly about what constitutes an employer, and it's also important to not think too narrowly about what constitutes an employee. For those of you that are familiar with retirement plans, there are lots of different ways to characterize people that work for you, and the government, in implementing the Affordable Care Act, is looking at the definition of a common law employee, of a controlled group of employers, or of an affiliated service group of employers, which means independent contractors, temporary employees. Those can be common law employees of the employer, even though you may not necessarily think about them as such in your current benefit structure. But for purposes of deciding whether or not you have to offer them coverage, if those people are working 30 hours a week or more, you really need to focus on whether they're a common law employee or not, because you may be obligated to pay a penalty with respect to that individual if they're not offered coverage. And similarly, you need to look beyond just your business to see if the owners of your company or other entities within your county or within your business are affiliated or closely enough tied to you so that the IRS would say that you're part of their controlled group or you're part of their affiliated service group. Because if you are, you have to count all of the common law employees of that broader definition of employer and use that number to calculate whether you're subject to the shared responsibility penalties. Plus, you have to use that number to determine whether you have to offer coverage to that person. Okay? One important note to that, however, is once you've determined that you're subject to the shared responsibility penalties because you have 100 full-time or full-time equivalent employees in your controlled group or your affiliated service group, if you then ultimately don't offer coverage or you don't offer affordable coverage so that you're subject to the shared responsibility penalties, the penalties are actually allocated to each business unit within the controlled group. And so if you had a controlled group of two, a group of companies, two companies that are part of a controlled group, one offers a plan that satisfies the requirements and the other doesn't, you would actually allocate the penalties to that company that doesn't offer the coverage. And so that's important to keep in mind. Moving on to what each of these penalties are. As I mentioned, the no coverage penalty applies if an employer just doesn't offer what's called minimum essential coverage to 95% of its full-time employees and their dependents. So you have a little bit of a gap. You don't have to offer minimum essential to everybody, but you have to offer it to 95% of your full-time employees or their dependents. And if you don't, you pay a penalty with respect to all of your full-time employees. And there's a way of calculating that, and I'll get to that in a minute. But just so you know, Minimum essential coverage is a very loosely defined concept within the Affordable Care Act, and essentially any self-employed or self-funded or self-insured employer plan or any insurance purchased on the smaller group, large group market, those will constitute minimum essential coverage. It may not be affordable, so you may have to pay the insufficient coverage penalty, but it will constitute coverage so you don't have to pay this $2,000 no coverage penalty. There's a couple of exceptions of what constitutes minimum essential or what does not constitute minimum essential coverage at the bottom of your screen, such as limited scope dental and vision benefits, things like long-term care insurance. These are not going to satisfy the requirements of minimum essential coverage, so you can't offer those benefits and avoid the $2,000 penalty. For 2015, it's just important to note, for those of you that are in that 100 or larger employer size, so that you're subject to these penalties in 2015, that the threshold of coverage is dropped from 95% to 70%, okay? And if you ultimately are subject to a penalty, instead of using 30, so you basically count if you had 100 full-time employees that you were required to offer coverage to, in determining the amount of your penalty for the entire year, you would subtract 80 from that 100, which would give you 20, and multiply that number by 2,000. So you get $40,000. That would be your penalty for the no coverage penalty in 2015. And it's important to note that the no coverage penalty is essentially the cap. Whether you offer no coverage or you offer coverage, but the coverage is insufficient, your penalty will never be any greater than what you'll pay if you offered absolutely no coverage at all. And so that formula for determining no coverage penalty is important. And it may also be important to help you understand whether you want to send your employees to the exchange or not, because for those employers that are right at 100, you get to deduct out that first 80, so you're only paying the $2,000 penalty on 20 of your employees. And it's also important to note that for 2015 alone, you are not required to offer coverage to dependents. The statute requires it, but the administration has waived the obligation so long as you can demonstrate that you made reasonable steps towards offering dependent coverage in 2016, when the law really gets moving. The insufficient coverage penalty is a penalty that you pay. It's a $3,000 penalty for the year for each full-time employee that you offer coverage to, but that coverage is either not affordable or doesn't offer minimum value. And basically that just means if you look at the grand scope of this group health plan, is the plan paying at least 60% of the expenses associated with the benefits that are offered through this plan? And the other standard that you have to satisfy in order for something to be treated as affordable, so you don't pay the insufficient coverage penalty, is the benefit can't exceed 9.5% of the employee's household income. And as you probably can figure out, household income for an employer is very difficult to determine, and so the IRS has given us a safe harbor. So a plan will be treated as affordable if the premium does not exceed 9.5% of the federal poverty level for the year involved. So for calculating the poverty level for 2014, it's $11,670. So if the premium for 2014 was $1,100 or less, basically $92 a month, it would be treated as affordable. So if you have minimum value, meaning the plan's paying at least 60% of the cost of the plan, and it's affordable, meaning the premium to an employee doesn't exceed 9.5% of the federal poverty level, then that plan is a qualified plan, so to speak, and you would not have to pay the insufficient coverage penalty if full-time employees are offered that coverage. So the big challenge that you're going to have, obviously, is figuring out who your employees are, both in terms of determining whether you're a large employer subject to the shared responsibility penalties, plus figuring out whether or not you have to offer an individual coverage. That's going to be the biggest challenge, and Brett Clark's going to jump in and talk a little bit about how to track employees. But as you do, as I mentioned before, keep in mind that you do have different definitions of what constitutes an employee. So independent contractors, leased employees, short-term employees, temporary employees, even agency employees, PEO relationships. You need to kind of look at those relationships and make sure that you're very comfortable that if you have characterized somebody as not your common law employee, that you're comfortable that that's a proper designation as the IRS and the Department of Labor define a common law employee. If you have relationships with workers and they look more like a common law employee, and you've hired them through an independent contractor arrangement, or you've hired them through an agency arrangement or a PEO arrangement, you should be working with those individuals and those service providers to negotiate agreements that protect you from having to pay penalties on the behalf of these employees. If you really don't believe they're your full-time employees, somebody else should be responsible for them and make sure they have coverage, or they should indemnify you. So those are some things to be thinking about. So as we go through this process, and Brett's going to talk about this now, you're going to want to figure out how to identify those employees that you need to be the most concerned about. And as I said, you have to offer coverage to your full-time employees, meaning employees working 30 hours a week or more. And if you don't offer them coverage, you'll either pay that $2,000 penalty or the $3,000 penalty if it's not sufficient coverage. But what you should be looking at is, who do I really need to pay attention to in my workforce? If I have a lot of variable hour workers, people moving up and down, they may not be working 30 hours a week on a regular basis this month or in that month, but over the period of a year, maybe on average they're working 30 hours a week or more. And if somebody reaches that 30-hour threshold on average during a year, you have to offer them coverage. And so these are some things you need to be thinking about, is like, who are my employees, what are their work habits, and who's going to create the biggest challenge for me to determine whether I have to offer them coverage or not. And you should develop some type of policy or procedure for tracking these individuals, identifying them, and ensuring that they receive coverage or are offered coverage in a timely manner, or be prepared to pay a penalty with respect to those individuals. And with that, I'm going to turn it over to Brett Clark to talk a little bit about tracking employees.
Okay, so I'm going to focus on two aspects of healthcare reform that I think are really the biggest sort of administrative burden for employers. Certainly just the whole cost of providing the coverage or the penalties is a huge thing for employers, but as far as administrative burden, I'm going to talk about two things. One is figuring out who your full-time employees are. You only have to pay penalties. You only have to pay penalties for your full-time employees, so it's really important to identify who your full-time employees are. And then second, I'm going to talk about the reporting requirements and what you need to be doing now to prepare for 2016 when you have to do reporting. Okay, so determining full-time employer status. And think about it this way, okay? The IRS is going to start auditing plans for shared responsibility compliance. And what they're going to do is they're going to come to you and they're going to ask for a bunch of documents, and one of the documents is a list of all your employees for whatever year they're talking about. And then they're going to look at who of those employees on your list were not offered coverage. And they're going to ask you to prove why each of those employees were not full-time. So that is going to be the employer responsibility, and that's what you really need to focus on. Everybody who you're not offering coverage, you need to be able to justify to the IRS why you didn't offer them coverage and why they shouldn't be treated as full-time status. There's two methods that the IRS has provided that you can do that. There's the look-back measurement period. You might find that familiar because we've had it for a few years. It was in the proposed rules. And there's also a new measurement period called the monthly measurement period, and I'm going to go through both of them. But just keep in mind, the reason that I'm going through this and the reason you need to focus on is either one of these methods is the only way that you're going to be able to show the IRS that this employee didn't have to be offered coverage, and so you don't have to pay a penalty for them. Okay? So the look-back measurement method, hopefully this is a little familiar because we've had it for a while. The idea is you have a measurement period. During the measurement period, you count employee hours. And if employees average during the measurement period 30 hours per week or more, then they are treated full-time for a stability period. The measurement period is between 3 and 12 months. The measurement period is generally the same length as the stability period is generally the same length as the measurement period, and in between you can have an administrative period of up to 90 days. So I've got an example here for how this works. For a lot of employers, the way that makes the most sense is to have your stability period be your plan year. And that makes sense because the stability period is the coverage period. People get into the plan as of the beginning of the plan year. So in this example, the employer has a calendar year plan year. They used a calendar year stability period. So they have 12-month stability periods, back out a 2-month administrative period, and then back out a 12-month measurement period. So every, November 5th or whatever, somebody in HR, whoever's figuring out who's full-time, runs a list of everybody that was employed from November 1st to the end of October, and calculates which ones were full-time, which ones averaged 30 hours per week during that period. And if they are, then you offer them open enrollment, and you have open enrollment in like the end of November, the beginning of December, and then for people electing coverage starts January 1st. And you can see in this graphic how everything sort of overlaps. You always have a measurement period going on that is determining your stability period, your eligibility for coverage during the next plan year. So that's the basic idea. It gets a little complicated when you talk about new employees. There's also this is a little bit helpful for employers in some circumstances. So what you do with new employees, the problem is you don't have a work history, so you don't know whether to cover them or not. What you do is you ask yourself whether you expect this employee to average 30 or more hours per week. You're hiring a new employee, you ask yourself, is this going to be a full-time employee or not? If they're going to be a full-time employee with a 30-hour threshold, then you treat them as full-time from the beginning of their employment. And you can have a 90-day waiting period where you're not going to be subject to penalties during the 90-day waiting period, but you have to cover them after the 90-day waiting period. Okay. For other employees that you don't expect to work 30 or more hours per week, and that includes part-time employees that you expect to work 20 hours per week or whatever, variable hour employees that it just depends. You're not sure how much they're going to be working. And also in this category, you can include seasonal employees. And these are employees that you might expect to work full-time. They might be working 60 or 70 hours a week, but you hire them at the beginning of an annual season, and you only expect them to work 6 months. So for all of these employees, you can treat them, you don't have to cover them as soon as they're employed. Instead, you can put them in a measurement period. And the measurement period can be between 3 and 12 months. And during the measurement period, this is the good thing, you don't have to cover them. And so essentially for these groups of employees, what you can do is have a 12-month sort of a waiting period, although you can't call it a waiting period because you can only have 2-month waiting periods. But in full compliance, the IRS is completely fine with that. You can delay coverage for 12 months while you're tracking to see if this employee is a full-time employee or not. And then you have an administrative period again, and then you have a stability period. Same idea as with your standard stability periods. You have a stability period that's generally going to be the same length as your standard stability period. So here's an example of how this works. The tricky thing is converting from these initial measurement periods and stability periods to your standard measurement periods and stability periods. And the way that ends up working is once someone has a full standard measurement period, and going back to our other example, we're doing a plan year stability period and measurement period from November through October. Once someone's been employed from November to October, then you take them out of this initial stability measurement period and you put them into your standard measurement period and stability period. The thing to remember here is that if someone essentially earns during a measurement period, if they're full-time during a measurement period, they earn the full stability period. So in this example, if someone averages 30 hours per week during their initial year, during the red measurement period, they get coverage during that entire red stability period, even if they their hours go down, and so they don't get full-time status during the blue measurement period. You can't drop it as of the beginning of the blue stability period. You have to offer them coverage throughout the end of the red stability period, if you're looking at the slides, the initial stability period, and then you can drop coverage at the end of the initial stability period. So that's how that works. There's a lot of detail in these slides that I'm not going to get into, but take a look at those if you have questions, and also, you can ask questions in the chat, and also feel free to email us if you have questions afterwards. We're happy to touch base with you on straightforward questions. So now we're going to talk about, that's the look back measurement period. That's option number 1 for proving that you don't have to cover some employee. The other option is the monthly measurement method. This has a very limited utility, but I just want to mention it so that you understand that the option's out there. The way this works is that an employee is a full-time employee if during that month they actually work 130 hours per month. Now, the reason why there's limited utility there is because you don't know whether you have to cover them until after the end of the month. And so it's not going to be very useful for employers at all. The one thing that might make it useful is what I call here the first 3 months free rule. And the way that it works is that for the first 3 consecutive months that an employee works 130 hours, they're not treated as full-time, and you won't have to pay a penalty as long as in the beginning of the 4th month they're offered coverage. I've got an example of how that works. So let's say you set your plan up so that in order for an employee to become eligible, they have to work 130 hours in a month, and then there's a 2-month waiting period, and then they get covered as of the beginning again of the 4th month. When someone works 130 hours, that's the first month, and then you have the second two of the 3 months are your 2-month waiting period, and then you have to cover them as of the beginning of the 4th month. So you might be able to use that, but here's the big disadvantage there. The disadvantage is that you can only use the first 3 months free rule once. So let's say someone works 130 hours, they get into the plan, but then they're there in the plan for a while, but then they change their status and they go to part-time status, and they're no longer working 130 hours per month. And the good thing about this method is you can drop coverage. You don't have to keep them covered until the end of the stability period. The problem is what happens if that part-time employee now ends up picking up a couple of shifts and works 130 hours in the month. You don't get to use the 3 months free rule again, and so that employee is treated as full-time, and you have to pay a penalty for that month if a penalty otherwise applies. So I think the biggest way that this is going to be useful for employers is for employers that just decide, we're not going to worry about complying with ACA. We're just going to pay the penalty. Even if you do that, you still have to figure out who your full-time employees are so you know what the penalty is going to be. And you can just use this method. You can just look at hours worked, and everybody that worked 130 hours was a full-time employee for that month. Okay? So that is all I'm going to say about that. We're not going to get into those details, but again, take a look at the slides if you have any questions. I'm just going to take a second to answer a couple there's people have. Do on-call hours count towards the 30-hour threshold for full-time employees? That's a good question, and there's a little bit, one of those slides has the answer to that. You have to use a reasonable method, and what you got to focus on is how limited the employee is. If the employee has to come to if the employee that's on call has to come to your work site and stay there, then you generally are going to have to count those hours. If they can be at home and they are relatively free to do whatever they want, and they occasionally get a call, then you only have to count the time they're actually working. You just have to come up with a reasonable method. Another question, do overtime hours count in calculating hours worked? The answer is yes. Any hour worked is counted, and in addition, paid time off is also counted for your hours of service counting. Okay, so ACA reporting, this is, I just want you to, I have one takeaway I want you to take from this, and that is there is a lot of information that you're going to have to provide to your employees and the IRS in the beginning of 2016. And you need to start tracking that information in the beginning of 2015, because in the beginning of 2015, you have got to start figuring out now who has all the information you need, how you're going to compile it, and who is going to do the reporting for you. It's going to be too late if you're trying to figure this out in the beginning of 2016. You've got to start figuring it out now. There are two main reporting requirements for employers. One is the 6055 reporting, and this reporting is so that the IRS knows who has to pay the individual mandate. What you have to report is who you're offering coverage to. And you have to list everybody, including participants, spouses, dependents, everybody that's covered under your plan. You need to tell the IRS what month they were covered. And the reason the IRS needs that information is so they can say, well, so they know who had coverage for one month, and so that they don't have to pay the individual mandate penalty. So that's 6055. The 6056 reporting is geared towards the IRS understanding whether you are complying with the shared responsibility requirements. And so that goes to who are you offering coverage to, who are your full-time employees, do you have minimum value, are you affordable, things like that. So that's the difference. The 6055 is actually a lot easier. Number one, for insured plans, the insurance provider does it. You don't have to worry about it at all. For self-insured plans, regardless of whether you're subject to the shared responsibility requirements or not, no matter what your size, how many employees you have to do the 6055 reporting for self-insured medical plans. It's pretty straightforward what you have to report, just like what I said. You have to report who you're offering coverage to. The one tricky thing there is that you also have to provide Social Security numbers. And a lot of times insurers don't have that. They have to worry about how to get that on their own. But if you don't have and employers have Social Security numbers also, but for example, if you get a TPA to do this reporting for you, your TPA might not have Social Security numbers. There are procedures that you can go through, and essentially what you have to do is each year for 3 years you have to send a letter to the person asking for their Social Security number, and if they don't provide it, you can just provide a birthday. But that can be a real pain. You might want to figure out if you can somehow get the Social Security numbers to whoever's going to do this reporting for you. But the really complicated one is and I do want to mention that the due date for this is the same. The way it works is just like W-2s. It's due January 31st. You have to provide the information to the employee, and the form that you're going to use is the form 1095B. And then you have to, by March 31st, you have to also provide, have to electronically submit all of the 1095Bs that you submitted with a transmittal that aggregates the information. Okay, now 6056 reporting. This is the shared responsibility reporting. So you only have to provide it if you are subject to if you're a large employer. The first thing that Brett talked about, if you are over 50 FTEs. Now, thing to remember is for 2015, even if you're under 100, if you're over 50 FTEs but under 100 FTEs, you still have to do this reporting. And you'll certify in the report that you're not subject to shared responsibility, but you still have to do the reporting for 2015 and later years. There is a ton of information that you have to provide. It makes sense what you have to provide. You have to provide enough information so the IRS knows whether you're complying with shared responsibility or not. And it comes from, the biggest problem I think that employers are going to have is that you don't have one person that has all this information. Your payroll processor has some of it, your TPA has some of it, your insurance company has some of it, your insurance company will have some of it. You've got to figure out how you're going to get all of that information and compile it so that in 1 month in January 2016, you can get everything compiled and get it submitted, because this is also provided on a very similar basis to W-2s. It's due by January 31st, the form to each employee. And the reason, it makes sense, the reason that you have to provide these forms by January 31st is because employees need them to complete their tax returns, report whether they have satisfied the individual mandate, and report whether they're eligible for premium tax credits. And then again, you have to compile all of the information and send it with the transmittal form by March 31st. So, I mean, I think it's pretty basic. It's pretty simple to understand sort of what you have to do. The really hard part is figuring out how you're going to get it all done. Okay? So, move on to, we're going to go away from this technical morass, and we're going to kind of,
what does it all mean?
Yeah, what does it all mean?
So, just kind of to sum up what's been illustrated by Brett and myself here, is that there's just a ton of information, a lot of moving parts, and there's obviously a little bit of a shift in kind of what people think of as coverage and who should be covered. And what we suggest employers do, particularly since depending on your size and your turnover, the people that are working on this issue today, that are working with your consultants and your lawyers and working on setting up plans and arrangements that are going to satisfy these requirements and identifying and tracking employees, those people are probably not going to be working on this in the years to come. There's going to be turnover, there's going to be changes in the business, and what we recommend is that employers document the decisions that they make and come up with a policy for tracking their employees and for measuring employees that aren't full-time and determining whether they do become full-time, and just putting it in writing in a policy that can be shared from individual to individual as these responsibilities change within an organization. And that's one of the things that we've spent a lot of time working on with our clients, is not only helping them to understand these rules, but documenting some of the decisions that were made in terms of like which measurement period is going to be used and who they're going to treat as a common law employee, who's not, identifying service providers that you may want to have agreements with that indemnify you if they're not offering coverage, but those people could possibly be characterized as your employees, things like that, documenting it, get a policy in place, and have some institutional knowledge, so as these rules remain in effect but people change, you're going to have the ability to track that. And so the next kind of phase of this is just talking a little bit about what you could be doing or should be doing, or maybe some of the things you've been hearing in the media about strategies that employers are utilizing to address changes in the rules. And so what I'd like to do again is kind of put it all in context. From our experience, the companies that are being hit the hardest, and in fact we've even had calls with people in the healthcare industry that are struggling with whether they're going to offer coverage in 2015 or just send their employees to the exchange. And it's those employees that are above 50 full-time employees but below 200, because we basically think of the 200 participants as the threshold. It could be lower, but generally speaking, the threshold for self-insuring is kind of at that 200 employee level. And then the threshold for the small group market is below 50. So it's kind of that group between 50 and 200 that have seen the most significant changes in their pricing in terms of the insurance costs that they're paying. And those are also employers that are fairly thinly staffed and have some challenges and just generally in terms of keep getting everything done and in terms of resources. And so those are the ones that we spent a lot of time working with. We obviously worked with large employers as well, but there's some things that are out there that are going on that these employers might want to focus on, as well as large employers, to help them think about ways of addressing the changes in the rules and complying with the Affordable Care Act. So as you think about maybe sending your employees to the exchange or developing some kind of plan where you're minimizing the number of people that you have to offer coverage to, think a little bit about both hard factors and soft factors. So the first one that may not be intuitive to everybody is that the cost of sending your employees to the exchange may be significantly less than the cost of offering coverage to those individuals. So if we go back to the example that I talked about earlier, where an employer has 100 full-time employees in 2015, that employer can eliminate or take out of the calculation of the $2,000 penalty 80 employees. So when they do the calculation to determine how much they're going to pay to the government for 2015, it will be 2,000 times 20, which would be $40,000. That's going to be far less than what those employers would likely pay for providing health coverage to those individuals. But you have to couple that issue with the fact that the penalties are not deductible. Healthcare plans maintained by employers that are for-profit, that subject to tax, this doesn't really impact 501c3 entities and governmental entities, but for-profit employers, they get to take a deduction with respect to the benefits they offer their employees. Well, the penalties are not deductible, but benefits are. So those are some things to think about. In addition, if you're going to change your benefits, you may have to increase the compensation you're paying, particularly to your key employees. So if you drop health coverage, send your employees to the exchange, those employees may not be eligible for tax credits on the exchange because they exceed that 400% of the poverty level, and so they're going to be paying with after-tax dollars for the insurance they purchase on the exchange. And so what are you going to have to change your compensation formula to make these people whole, and what will that cost you? In addition, think about the soft factors, things like recruiting and retaining employees. Think about the complexities of changing hours and keeping people below the 30 threshold, and will your competitors across the street who have coverage or who aren't subject to these penalties not have to play those games to keep employees out of their plans, and will those employees leave and go across the street because of that? And the other aspect of this is just the discrimination rules. The Affordable Care Act imposes penalties on employers that discriminate in the way they offer benefits. And they haven't issued regulations and guidance on that, but as this law unfolds beginning in 2015 or 2016, once that regulation is issued by the government, you'll need to look at how those discrimination rules impact the design of your benefit programs.
Okay, so we're just going to go through some scenarios that we've seen out there of what employers are doing. And the first one is, and we definitely see a lot of employers that are going to play. These rules sometimes are called the play or pay rules. People are going to play. They're going to fully comply with shared responsibility, provide coverage that is affordable and minimum value to all of their full-time employees. They're going to track their full-time employees. There's definitely some pros here. No penalties, and really, I think employees get high-quality benefits. This is great if you want to be seen as a good employer that provides great benefits, fully comply with shared responsibility penalties. But there definitely is a downside, and most of it is cost. It's expensive, and it gets more expensive as time goes on. If healthcare costs continue to rise, you still have to keep it affordable, and so the employer ends up getting stuck with paying more and more for benefits to its employees. Another thing that can happen, especially if you have a workforce that you're not sure whether they're going to elect to receive benefits, like for example in restaurants and in staffing firms. Even if you want to offer them good coverage, insurance companies look really closely at what the take-up rate is going to be. And if you have a low expected take-up rate, then that makes your insurance costs even higher. It can be very very significant if you don't expect a lot of your employers to purchase insurance. It's a special, now this is going to be most helpful for the employers that are already offering coverage to most of their employees. You might have to be careful with the premium to make sure that it's affordable, and you might have a few people that you have to, you might have some part-time people that occasionally work over 30 hours per week, and so you end up having to track those employees more carefully to make sure that you cover them if they end up being full-time. So it kind of around the fringe of those types of employers, that's where the difficulty lies. But for large employers that are already offering generous benefits, those are most of the employers that are going to play here. A couple of variations on this. You can play with the premium so that your coverage is unaffordable for some employees, and that could be really helpful for them because the premium for the affordability analysis looks only at the employee-only coverage premium, but premium tax credits are available on the exchange for not just the employee, but for everyone that's being covered. And so it can be really helpful to employees if you make, for low-income employees especially, if you make the cost of coverage high enough that for your low-income employees it becomes unaffordable, then they can go to the exchange and get coverage on the exchange, and that just depends on your workforce. You'll have to pay a penalty, but it might end up being cheaper for you to pay the penalty, and the employee is happy with you because they end up paying less for insurance on the exchange. That's one thing that a lot of employers are thinking about. Another option, which can be very expensive, is just cover everybody so you don't have to track full-time employees. And another thing that we see a lot, and this is also applicable for coverage on the exchange, the way that insurers can save money, the way you can save a lot of money on insurance coverage is to limit your provider network. And so there's a lot of coverage even on the exchange that has limited provider network, and you might be able to do that too. Again, that might make your employees unhappy, but it's just a give and take with the cost. It might be worth it because if you save enough money.
So if you decide not to play and offer coverage and instead elect to pay by sending your employees to the exchange, as we talked a little bit about before, that may not be a bad option, particularly when you are considering the fact that the cost of paying the penalty may be smaller than the cost of offering coverage, particularly in 2015, where if you're, again, at that 100 employee or very close and you can take out 80 before you calculate the penalty could really be quite small. In addition to that, one thing to think about is offering coverage in and of itself has a cost. I mean, there's overhead, administrative costs, record keeper costs, lawyers' costs, benefits personnel. So not only does the cost of insurance have an impact on your bottom line, but so does the cost of just maintaining a group health plan, and so that would be something else to keep in mind. As I mentioned before, these things aren't the penalties aren't deductible. It might impact your retention or your ability to recruit employees. And the other thing to keep in mind is just because you send your employees to the exchange and elect to pay the penalty, that you're still going to want to track whether these employees are entitled to coverage under the shared responsibility rules. You don't want the IRS just sending you a bill and having the employees decide whether or not they were full-time or not. You're going to want to track your full-time employees and determine who you would have been required to offer coverage to, so you know what your penalty is, as opposed to having the government basically decide who you should have offered coverage to. So tracking doesn't go away just simply because you've elected to pay, unless you want somebody else deciding what your penalty amount will be. The groups of people that we're talking to about paying, just sending their employees to the exchange, are employers that historically have not offered coverage. They've got a high turnover workforce. They've got employees that are younger and healthier, and so they just haven't historically had a problem recruiting. And the fact that they don't have a health plan hasn't been a problem to them. For them, you know, particularly with the reduction and the counting in terms of who you have to pay the penalty on, it makes more sense to them to send their employees to the exchange and just simply pay the penalty. Also, if an employer has to make a lot of changes to their plan or ramp up in terms of administrative costs, again, look at those administrative costs, look at the additional costs associated with changing your plan to comply, because those costs need to be factored in determining whether or not it's worth it to continue to offer coverage.
Okay, so you might have heard of skinny plan. This is sort of a strategy that some providers have come up with, and the idea here is that you limit benefits to the minimum benefits that you can offer and have a group health plan and comply with all the rules. And essentially what that means is you have to provide coverage, free coverage for preventative care. So that's what a skinny plan is. All it does is it offers free coverage for preventative care. Now, a skinny plan constitutes a minimum essential coverage. And so it satisfies the no coverage penalty. If you offer this to all your employees, it's very inexpensive. And for you, it satisfies the no coverage penalty. And for them, it satisfies the individual mandate penalty. So if you have a lot of employees that are mad that they want to avoid the individual mandate, but they don't want to pay for major medical coverage, you can offer them a skinny plan, and they might like it because this is something that is not available in the individual market. It can only be provided by an employer. You know, obviously there are significant downsides. It's really bad coverage, and you have to be very careful if you're going to tell your employees that it's really bad coverage, so they don't think, oh, I've got insurance, and then all they get is preventative care, and when they get sick, they have nothing. You have to be really careful. You're definitely not going to win the Employer of the Year award unless you do, for some reason, you have like a young population that don't really want to buy full-fledged medical insurance. They might appreciate the skinny plan option. The big issue here is that it does satisfy the no coverage penalty, but it doesn't have minimum value. Skinny plan will not have minimum value, and so for everybody that declines coverage under the skinny plan and goes to the exchange and gets subsidized coverage, you will have to pay a penalty for them. And there's a potential that you could have a penalty just as high as if you hadn't provided any coverage at all, plus you've got the cost of the coverage that you did provide. So like I said, if you have a young workforce, a healthy population, this might be an option. And also, if most of your employees are either extremely low paid, so they're not going to be eligible for credits, or extremely high paid, so they won't be eligible for credits, then you'll avoid the insufficient coverage penalty also.
So as a kind of a twist on the skinny plan concept is the idea of offering both a skinny plan as well as a broad-based group health plan that satisfies all of the requirements for minimum value and is affordable. So this is essentially covering the universe of offering minimum essential coverage through the skinny plan, as well as offering minimum essential coverage through the major medical plan that's both minimum value and affordable, so that you're essentially offering your employees the option. I can purchase the skinny plan and satisfy the individual mandate requirement, but it's extremely inexpensive, or the employees will have the ability to decide, well, I want to purchase the full-blown group health plan that satisfies the affordability requirements and the minimum value requirements. The benefit of this is that you have both minimum essential coverage, so the $2,000 penalty is satisfied, plus you have a plan that's offered to everybody that's both minimum value and affordable. The downside of this is it will not allow your employees to go to the exchange because they have been offered coverage that's both minimum value and affordable, and that's minimum essential coverage. So they will not be entitled to premium assistance subsidies or tax credits on the exchange. You might want to utilize this type of arrangement if you have a lot of healthy employees or a lot of older employees, so you have a fairly diverse workforce and they can basically decide which option they want to choose, which is best for them. Another way of utilizing this strategy or this approach is offering the skinny plan as essentially insurance against the $2,000 penalty if you have a high number of variable hour workers that you are concerned that you may not be able to track. If you offer the skinny plan to everybody, regardless of their hours, then you're not worried about missing a person here or there that may be a variable hour worker that you don't timely offer coverage. Now, you may still be subject to the $3,000 penalty for people that you don't offer the group health plan to, the broad-based minimum value group health plan, but at least you've offered them minimum essential coverage, and so you won't be subject to this $2,000 penalty per full-time employee. Now, one of the things that's come up, and we're seeing a lot of this, is the kind of the skinny plan combined with an HRA to purchase insurance on the exchange. HRAs and FSAs, historically, employers have been allowed to establish these so that the employee can go out and purchase their own individual coverage. We know that you cannot offer an HRA or an FSA that allows the employee to go and purchase insurance on the exchange. That's written right into the statute. In addition, the IRS has recently published guidance that you cannot use an HRA or an FSA to purchase any kind of individual insurance because that doesn't satisfy the requirements of a group health plan under the Affordable Care Act. So one of the tactics that we saw more recently this year, at the end of last year, is they'll add a skinny plan, which constitutes minimum essential coverage, that doesn't have the lifetime or annual limits on it. They'll add an HRA, then allow the individual to use the HRA to go out and purchase individual insurance on the open market. The IRS has said that doesn't work either. So you can't essentially use the skinny plan to establish an arrangement wherein you allow your employees to purchase their own individual policies through an HRA.
Okay, so I'm going to go through these next two kind of together, reference pricing and exclude inpatient hospital coverage. But the idea for both of these is instead of going to the ultimate minimum like the skinny plan, go to the design your plan so that the cost is minimized, but you still have minimum value. So reference pricing, the idea here is that you just put limits on how much different specific services the plan will pay for specific services. Like, for example, a knee surgery. You say, we will only pay $5,000 for the knee surgery, and then the employee has to go and find a provider that will do knee surgery for that much, or pay the rest of it. And people in the industry have found that this can really save a lot of money. And you can design it so that it's minimum value. You can save a lot of money. The downsides of it are, it takes a lot of employee education. They're not used to having to worry about how much a procedure is going to cost. It might be hard to find providers, and the IRS does have some concerns about how this applies in the context of out-of-pocket limits. You might not be charging anybody up to the $5,000, but what if you go with somebody that's going to charge $10,000 and you have to pay $5,000 out of pocket? Does that count against your out-of-pocket limit or not? And that's not entirely clear yet. So there are some IRS concerns about this. But again, the benefit is significantly reduces cost of coverage, and it still has minimum value, and it can be affordable, so you don't have to pay penalties. Same thing with the next option. If you exclude inpatient hospital coverage, you cover everything except your plan does not cover inpatient hospital coverage. This can be designed so that it has minimum value and it saves a ton of money, because most of the risk of high bills is when a participant has inpatient hospital coverage. Same thing again though on the con. You're not protecting your employee. I mean, your employees, you have to educate them and make sure they understand what the limit is here. And when someone has a really expensive medical procedure, they can be very unhappy because it might not be covered at all when they might have expected it to be covered. Both of these plans are generally limited to the self-funded market, but if you really want to be aggressive in minimizing costs, then these are two options you can consider.
All right, I'm going to wrap up here really quickly. I know we're out of time, and so I just wanted to just point out a few things on the final slides in terms of using part-time employees. You know, you hear a lot about you're basically switching all of your employees to part-time, and as you can probably tell in terms of calculating whether you're subject to the shared responsibility penalties or not, even if you switch all of your employees to part-time, you have to add them up together and come up with these full-time equivalents. So that would still make you subject to the shared responsibility penalties, even if you've dropped everybody down to part-time. What part-time can do is it allows you to avoid having people that are at the 30-hour threshold, so you don't have to offer them coverage. But one of the things that our clients are figuring out is like, okay, I'm subject to the shared responsibility penalties, but my competitors across the street aren't. And so if I drop all my employees down to part-time, they can't get enough hours to work, or they don't like this variability in their schedule. And so now they go across the street to a competitor. So there's obviously a lot of soft costs associated with that. The other thing to be aware of is too much manipulation and too much overt manipulation of your health plan to try and avoid the Affordable Care Act can run you into problems with ERISA and the interference rules are interfering with a person's right to benefits, and you may run the risk of being sued by an employer, or by an employee, or under the ACA whistleblower rules, which is again another rule that prohibits you from interfering with an individual's right to go to the exchange. So keep those things in mind when you're changing your employee workforce and their work hours to try and mitigate your exposure under the shared responsibility requirements. The other thing to do is to go to a PEO or to a staffing agency. Some companies could really benefit from going to basically outsourcing all of their employees or all of their employees at a particular facility to a PEO. And by doing that, you still are going to have to pay to some extent for the health insurance because the PEO or the staffing agency is going to pass along the cost of health insurance coverage to you. But in some cases, a staffing agency or PEO can benefit from a lot larger pool of employees to drive down health care costs. So a PEO or a staffing agency may be able to pass along those cost savings to you. But keep in mind that in particularly a staffing agency scenario, those employees may be your common law employees and you don't even realize it because under the terms of the agreement, the staffing agency takes the position that they're the common law employer of that employee. But the Department of Labor or the IRS may not agree. In a PEO situation, you're treated as a co-employer. Both the PEO and the real location employer are treated as co-employers. So in both situations, whether it's a staffing agency situation or a PEO situation, you're going to want to make sure your agreements with these providers addresses who's going to offer coverage and who's going to be responsible for paying penalties if coverage isn't offered timely and an appropriate situation, so that if you as the location employer are characterized as the common law employer by the IRS or the DOL, you can look to the PEO or the staffing agency to reimburse you or indemnify you for having failed to offer coverage to those particular individuals. I think that covers it. All right. So we are out of time, and we just have a small number of questions. So I'm just going to hit those questions very briefly. And for those of you that have heard enough about the Affordable Care Act, please feel free to log off. But for those of you who posted a couple of questions, we're going to answer those now. So the first question.
I think there's actually one more. Someone asked whether if you're over 100 employees, whether you get whether you have to cover 95% or 70%, and that reduction of the 95% to 70% does apply regardless of whether you're over 50 or 100 FTEs. I don't know. Someone asked whether if you have between 50 and 100 employees, can you go on the shop exchange?
Right. So I'd have to look into that because the shop exchange does go up to 100 employees, but I'd have to look if it's 2015 or 2016. I just don't remember off the top of my head. But it will eventually jump up to 100 employees. There's just been a lot of changes to the shop rules. The shop ended up being a big flop last year, and we just need to go back and look to see what the status is of the shop in Idaho. Or in any other state for that matter. Yeah.
We're in Idaho. But
Sorry.
And then someone asked whether health insurance is available without like a minimum hours work. And I think it is very common for insurance policies to only provide coverage if you have, I mean, in the past it's been like you're expected to work 32 hours per week or 38 hours per week or not. The insurers, I think, generally do like to keep it with full-time employees so that are more regular employees, and they're going to have consistent coverage from year to year. But under the new rules, especially in the small group market, there are rules that you have to, the insurer has to offer coverage, the coverage that the small group market wants. What they can do is make it expensive, and so especially if your part-time employees are very in flux, then it might make cost savings to not cover them. But you generally you should be able to get the option at least, but it might be expensive. Have any thoughts on that, Brett?
All right. So that concludes our presentation. Please feel free to email either of us, Brett Busacker or Brett Clark, on the question if you have any questions, or if you want to just chat a little bit about your situation. And we're spending a lot of time working on this, and we're happy to chat with you. So thank you for participating, and that's it.
Have a good afternoon.